David, welcome to this episode, being a wonderful guest on Ask an Attorney, the Attorney's Guide. And I love your focus of law. As an entrepreneur for the last, I don't know, over 35 years, I created my first business, believe it or not, at 19 years old. And I've created more brands than I could probably think to count. And I think I own over 50 domains right now. So I absolutely love intellectual property law. And I want to know what made you get into it because there's so many types of focuses of law possible. Why IP for you?
Yes, thank you, Vivian. Happy to join you here on Ask an Attorney, the Attorney's Guide. My path to intellectual property is actually very unusual because it started when I got my PhD in mathematics a long time ago, and I was a professor of mathematics for a bunch of years, and then I switched to software development. I was a
Wow.
software engineer for 12 years. And being a software engineer is a great thing. I enjoyed that a lot. But after 12 years of that, I said I need to do something different, and I discovered the possibility of going into intellectual property law. So I went back to school, got my law degree, and that's what I've been doing since then.
You look really young to have had three careers. You must be immortal because I think you've aged incredibly well. And because I know you're not in your 30s, so great job on having those immortal genes.
Yeah. Well, thank you. I appreciate that.
And I know you didn't just get your bar, past your bar recently. How long have you been an IP attorney?
Yes, I completed my degree in 2007, and in 2007, I started work at a large law firm, and got a lot of very good experience from some very good people and at Morgan Lewis. And then only about 2 years ago, I launched my own patent law firm, which is substantially smaller, just a small number of people, and that's going well.
And so, wow, you've been an IP attorney for almost 20 years already.
Yes, yes.
I told you look immortal considering it's your third occupation. That's great job. Great genes. Thank your mom and your dad.
Yeah, yes, thank you.
I was just surprised because you just look great. And to know that you've been an IP attorney for over 20 years, I can't wait to get this to the story portion of this podcast because I know we're going to delve into a few different focuses, right? So I know there's several different, as somebody who's, like I said, I've written several books. And so you have copyright aspects, you have different types, and I want to know what those are. So, what are the main forms of IP, if you will?
Yeah, and this is actually it's really important to understand all four because sometimes, depending upon what your business objectives are, you use one or more of those types of intellectual property. So the four main types that we deal with are copyrights and
Rights.
trademarks and patents. And one that maybe doesn't get always heard about, which is trade secrets.
Oh,
So we got those four. And so when we're looking for protection, we need to evaluate all four to see whether they're appropriate depending upon what your business objectives are.
imagine that entrepreneurs must be very frequent customers of yours because as someone who's been an entrepreneur 35 years, every time, if not just entrepreneurs, I just thought it's like, what about podcasters? I understand there's 1.9 million podcasters. Well, that's building a brand. What type of which form of IP would a podcaster need, for example, or a YouTuber or an influencer?
Yes. So there's probably, well, first of all, copyrights. A copyright protection is essential whenever you're creating new creative content. And so copyright protection is actually fairly easy to get because you just file a copyright registration with the government, and you get a registration number, and it's done. So there's no examination process. It's just you file it and you got it, and it's relatively inexpensive. your copyright. And so registering your copyrights is a good thing. And another important part about copyrights is that they last for a very long time. The
How long do they
Yeah,
last?
yes. How long do they last? Yes. Copyrights will last in general, lifetime of the author plus 70 years. 70 years. So it's actually quite a long time. It's like, your heirs will have the copyrights long after you're gone.
I just heard something. The movie "It's a Wonderful Life." I just heard that the reason they play it at almost every Christmas is that the movie house accidentally had the I forgot it's copyright expire for a
Oh,
while.
yeah.
I just
Well,
heard that
right.
yesterday.
Yes, and also the rules on a copyright term have changed over time. So the rules that I said about life of the author plus 70 years has been in place since 1978. But if you go back
Hmm.
before that, the rules were a little different. And so if it's something very old, then we have to go back to, okay, what were the rules in place, when these movies were created? But there's other examples that, for example, some of the early Mickey Mouse cartoons are no longer in copyright, which is why you see some of those being used by people because they're no longer in copyright.
But wait a second, wouldn't Disney do anything about that, or could they?
For In terms of copyright protection, there's the rules are what they are, so they can't prevent people from using some of the specific early cartoons. They can't prevent that, but there's a lot of other things in terms of building up a valuable brand that Disney has done. And so it's not just like the Mickey Mouse that was in these early cartoons. There's a much bigger brand around that, and Disney has done a very good job of protecting that brand.
So I know they are. I can't imagine otherwise. But so you're saying a regular person who's a small business owner, entrepreneur, can have the same rights to protect really what their business is built on. So when I bring up that there's 1.9 million podcasters and all the other influencers, every single one of them has a domain and a brand to build, and that they've put money, time, energy, effort, money into it. So do you really think every single one of them is filing a copyright to protect their brand? Is that what they should be doing?
They should be, because it's like I said, it's simple and it's inexpensive. And if somebody copies your work, um, you really need to have the copyright registered in order to be able to enforce your rights. Yes, you should. Because of the fact that it's simple and inexpensive. Yeah, you should be doing that. If something is valuable to you, then make sure that you've got the rights so that you can enforce it.
Something is your name. So can you send someone copyright your name?
Okay, that's a good question. So that wouldn't be a copyright. That gets us into trademarks. So
Sorry, Ron Turner. See, this is why I
yeah,
wanted to
yeah.
understand it.
Yeah. So that's something you can trademark. And in fact, I have a client who created a brand that was her own name. And so she has a trademark on her name in terms of her line of jewelry that she has produced.
Really?
And so that can be done. For example, too, like even with my business, I started the firm Sanker IP. So that includes my name, and like just recently we actually filed for the a trademark on that name. So yeah, you can absolutely file for a trademark for a name, and it doesn't have to be a name. In many cases, it's not it's not a name, but you can file for a trademark for any mark that is going to represent the goods or services associated with that mark. And I mean, the good thing, trademark registrations are also fairly straightforward, fairly inexpensive. A trademark application, though, does have an application process and examination. So an examiner will look at it and determine, okay, is somebody else using this mark, to make sure that they can allow it. And that process typically takes up to a year to get your trademark issued. One good thing about trademarks is if you've got trademark protection can last forever. There's
Forever?
renew, yeah, it can
But
last
wait a
forever.
second. I've got to ask, for how could something last forever? Then wouldn't it going back to, how is that different like than the Mickey Mouse that expired or It's a
Yes,
Wonderful Life that expired?
yeah,
If it could be forever.
right, and there's a slight difference there. So some of those, say the early Mickey Mouse cartoons, those images, it's just an image, and so the copyright protection can expire. On the other hand, to the extent that Disney has created is using Mickey Mouse as a trademark for the business, that can last forever. And so
Oh.
yeah, and that's really important. So, for example, Coca-Cola has a trademark on its mark, and if we could see into the future 100 years or so, they'll still have that trademark and with their mark. So trademarks can last forever as long as you pay the renewal fees that come up. Every like 5-10 years, you pay a small renewal fee.
My curiosity is if it's so I obviously like everybody does, hopefully you Google yourself to make sure you know what's out there about you. So
Yes.
obviously I've Googled myself frequently because I do continual content creation. And unfortunately for me, there's other Vivian gas bars. So then my
Oh,
question is, if I trademark my name and somebody else uses it, but I'm sure I'm not the only one. There's lots of people who have the same name. So, like for example, and I'm just throwing out a completely random. There's a lot of Rodriguez's or Lopez's or whatever.
yes.
So, how can you say, well, I'm using your name if you're trademarking something that could be deemed common or
Yeah,
frequent?
and and
So
and that
lots
would
of people
that's
have those last names that are frequent.
yes, and that's part of the examination process. So you won't be able to get a trademark on a name if it is too common because it's not unique. So if somebody has a completely unique name, yeah, then it's pretty easy. As my client had a name that was unique and was able to trademark that. But if somebody else has exactly the same name, if there's a very common name, then it would be difficult to trademark that. Yeah.
I'd love to know. You said the trademark can be forever. Copyright is a lifetime plus 70 years. And these are, I guess, can be willed down to your heirs,
Yeah,
right?
absolutely.
And so how long is it? What about the patent? So if we're going overview,
Yes. Yeah. That's a good question about let's talk about the patents and both the examination process for patents as well as the term. And maybe let's start off with just the term of a patent. So you can get up to 20 years from filing. So if I file an application today and it takes 3 or 4 years to get it issued, it's still going to be 20 years from the date of filing, as opposed the rules were originally you had time from issuance. Now it's from filing. So 20 years, as long as you pay the maintenance fees. And the reasoning for that is that if you've come up with an invention, you're getting a monopoly on this invention in exchange for telling everybody else about it. And so it's like you don't get a monopoly for free. The government's saying, okay, you get a monopoly, but you got to tell us all about it, and your monopoly is limited. So
only for
a
20 years?
20 years, yeah, which for many things is actually quite good for inventions that deal with software. In many cases, 20 years is much longer than they possibly would need. On the other hand, for say a new pharmaceutical drug, 20 years, I mean, is not necessarily that long because like, oh, you're still making lots of money off of this. And so drug manufacturers try to do anything they can to, sort of extend their exclusivity as long as possible. And sometimes there's tricks they can do, but that's a case where they're going to use the full patent term because that's when as soon as it gets out of patent, then generic drug makers can create the same
I was gonna
thing.
say, but can't they make a tweak to it to keep it extremely similar, but then renew a patent to keep their hold on it?
Um, there are various ways to try to do that. In most cases, it's tough to do that because the initial disclosure, you actually disclose not just the very specific formulation, but a lot of it's a wide array of very similar formulations. And so the disclosure usually covers all of that. And so you can't come back later and say, oh, now I want to claim this other formulation to extend for more years. It's like, oh, well, it's already disclosed. So, yeah, but there are things they can do. For example, like take a drug that maybe you include that new drug in a new buffer or other thing that makes it more effective, or in combination with another pharmaceutical compound. So there are ways that you can combine it to increase that length of time if you can. So there are ways to do that.
I just realized, like, since you're going to be in practice now, you have a 20-year anniversary coming up in a year. Did you file any patents in your first year of being an IP attorney that are going to be they're going to be up
Expiring.
in a
Uh,
year?
um,
Expired.
good question. Yeah, I
How
assume that's
stop
true.
that?
Yeah,
You have to think about that.
yeah. So I haven't looked at those. But the other thing I was going to say about patents, unlike copyrights, which have no examination, trademarks have just examination to make sure they don't are new and not overlapping somebody else's work. That a patent has a much more extensive examination process to make sure that there's nobody else who's created that invention, as well as making sure the invention is not obvious in light of other things too. So it could be that your invention could be obvious in light of, say, three other things and say, oh, well, based upon A, B, and C, your invention's obvious. So the examination process is far more extensive, and the process usually takes a few years. So
Wow.
it can, there's no limit to how long it can take. And there's sometimes it can take, 4, 5, 6, 10 years. I mean, it can take a long time to get it
So the
back.
question I would immediately wonder, once you submit something for a patent, can you do anything with it, or you just sit on it waiting for approval?
Oh, so absolutely, as soon as you file, you absolutely should be using it. So first
I didn't
thing,
know.
yeah, first thing would be to make sure you mark any of your goods or services as patent pending, because you do have a patent pending, and so you let people know that you have this patent pending on your goods or services. So that's one thing to do, and it's also if you can go into license negotiations or selling your rights. Once you've got something filed, there are rights, even if it's in an application. You still have rights. So people will definitely look to licensing or selling their rights as soon as it's filed.
Wow, there's so much in complexity in this, but to me, it seems that it's necessary. It's part. So when you start a business or you have an invention, you grab a domain, you have a name, you have to have a business entity, but this should be the next step. So my question is going to be, which step in having a business do you bring IP protections in?
Yeah, and it really can. It depends on it depends on the timing. So filing for, say, a trademark on your name, that's something that should be done very early, because there are times when people have come up with a name, they like their name, uh, uh, but don't necessarily file for a trademark until later, and it could be too late because somebody else could have already gotten the name. Uh, and then that's a real problem because you may have to change the name of your business after it's already been going for a while. Establishing the mark and filing for a trademark application early is important. In terms of patents, it really depends on the progress toward your inventions. It's like, well, are they? Do you actually have these inventive ideas worked out? Do you have the implementation details worked out well enough? And as soon as they are, that's the time to file for a patent. So it could be right away. I mean, there's sometimes that people they already know what their invention is, before they've even established a business entity. In which case, we could file for a patent application even before the business entity exists. I do that sometimes, and then after they've established a business entity, assign the rights to the business entity.
So I think it sounds like chicken or the egg. Is it a business attorney or a IP attorney who's first or second that you
Yeah,
contact?
yeah, and that's one of the reasons why I work together with business attorneys. That's like, if people come to me first, I say, oh, and do you need this additional corporate work? Okay, I have some good people I work with, and conversely, some of the attorneys I work with, they will say, oh yeah, we need somebody to do the IP work. So yeah,
Absolutely necessary, because then you can put all that time, money, energy, and oh, by the way, money into it, and then someone else takes it, and what's the point? You just
uh,
wasted a ton of your time and money.
absolutely, yeah.
Effort goes without even mentioning.
Yeah, intellectual property protection is pretty important, and it's just a matter of finding out what the what the right form of protection is, and which reminds me with the fourth form, which we haven't discussed yet, which is the
You about the next one. You put it up first.
yeah.
So I want to know, when you have a business and you are creating something in a very unique way, is there a way to protect that?
Yeah, and so that brings up the fourth form of intellectual property protection, which is trade secrets, um, and and so trade secrets are a little bit different than the others. So first of all, a trade secret has no examination process at all, because
Nothing.
yeah, nothing, because it's like it's the whole premise is that you're keeping it secret, and you're keeping it secret from everyone, and that's why it's valuable. Is it's like, okay, by keeping a secret. The other part that's very interesting about trade secrets is that uh, uh, not only so, I think I'm talking too fast. It's not.
It's so genius. It just goes so quickly.
Um, yeah. So, and another important part about trade secrets is that it can cover anything that has business value. And so it doesn't actually have to be an invention like it does for a patent. So examples of what you could trade secrets for. So first of all, yes, you could keep a trade secret on an invention, but also like a customer list or a database.
Really.
Um,
It's evolving as you get additional customers. So how often do you
sure.
refile for a trade
Well, that's
secret?
what I say. So for a trade secret, there's nothing filed. That's like you just keep it secret all the time. It's just like, so yeah. There's no filing involved. Just like, okay, we just keep our customer list a secret. Um, uh, so the other an example of that too that people are very familiar with artificial intelligence now.
Oh my
Artificial
God,
intelligence.
AI.
Yeah, and artificial intelligence models. There's two key things that are virtually always should be protected with trade secrets. Is one is, what was my training data? So your training data that you have collected and invested a lot in, that's yours. So don't share it with anybody else. Keep that as a trade secret. The second thing is, after you have trained a model, your AI model, the trained model is basically just a bunch of parameters, and you also keep that as a secret. It's like, okay, so you don't let people know what that is. So those are some examples of things for which you could get keep protected as a trade secret, and you couldn't, and those are things that you couldn't get a patent on. And so a trade secret is really the right form of protection. And of course, because it's a secret, the secret can last forever. So you
If somebody comes after you in court and says, "That's my idea, you took it."
Right. So the question is, so if you have to go to court to prove something, I mean, you actually have to show that it was misappropriated. Did they acquire it by an illegal means? If somebody has taken your trade secret.
Sounds like corporate espionage.
Yeah, and there are so. Yeah, just briefly off topic, but it's like patent litigation is kind of dry because I've got a patent, they're an infringer, here's the proof that they're an infringer. It's like it's not and not exactly exciting and sexy in the same way as a trade secret. Because if there's a trade secret, you've got to show that this is misappropriated and somebody actually did something illegal to acquire your trade secret. So that can be a lot more exciting, in that sense.
What you just had pop into my mind is a stereotypical Mission Impossible. Like when Tom Cruise came down off the ceiling, drop down. So that's the lengths that people will go to get, whether it's a formulation for a product like Coca-Cola, which is the most famous possibly.
Yes, yes, and talking about that one is like, so in the same way that the name Coca-Cola will exist, 100 years from now, the secret of their formulation will exist 100 years from now as well. So they've got that protected. But usually trade secret misappropriation is rather than sort of espionage, it's a person working for one company who has access to the trade secret and then is hired by another company, and they say and they take the secrets with them to give to their new company, and so that's you got to have proof that they actually took it with them to use that at the new company.
Isn't that protected with NDAs? So if you're working someplace, so let's say you're a salesperson and you develop and you get access to the list because they're asking you to continually contact an existing client list. But as you mentioned before, a client list can be under trade secrets, right?
Yeah.
So how can, and let's say somebody gets hired by a competitor as a salesperson and they bring over those client lists, isn't that a common issue?
It can be, and that's one of the things that when a person does move from one company to another, both the HR department on the old company and the HR department on the new company should be doing something to make sure. I mean, both sides should be making sure that the employee who is moving doesn't take secrets with them. I mean, both sides want that to occur because the side where the employee is coming from is like, we don't want you to steal this. And the other side, the new company, if they're honest, which most companies are, is going to say, we don't want you to bring this information over with you because we don't want to get sued. We don't want to have to go to court about this. Yeah. And so they'll actually have them sign something to say that you are not bringing information with you. So both sides should be dealing with that to make sure that information is not copied.
You said that you don't need to file a trade secret. So how long does it last? Is it indefinite then, as long as they keep the secret?
Yeah, you can keep it as long as it's secret. And that's and that kind of goes into the topic of what can terminate a trade secret. One of which is reverse engineering, because
I ask you about that, if that's possible.
Yeah. So like if you've got your trade secrets included in say a widget, and you're selling that widget, then somebody can buy it on the free market and do all sorts of reverse engineering. And there's a lot of great tools for reverse engineering of products. And if they can figure out the trade secret by reverse engineering, it's no longer a secret. And
That,
so,
I was saying, does that also apply to patents for a physical
uh,
item? Like, as you mentioned, widget.
yeah,
So an item.
that is one of the advantage to patents because it doesn't, even if somebody reverse engineers it, it's like if they are practicing your patent, they're still an infringer, and so it doesn't matter how they got the idea. It doesn't matter whether they read your patent, reverse engineered, or what. So that's one of the strengths of a patent is it doesn't matter how somebody got the idea. If they're doing it, they're an infringer. Um,
And so I gotta ask, but what if you find that someone across the world? So let's say you file a patent in America, in the United States, and then someone simply goes, takes it to another country, reverse engineers it, manufactures it in, let's say, China. It's just an example.
yeah,
And then they bring it and import it back into America as a sorry, competitor. Yeah, if I could speak, that'd help. But that has to happen frequently. So then,
yeah. Um,
how do you prove patent infringement?
Yeah, and so there's laws to address that circumstance. So in those circumstances, first of all, if somebody copies the idea and manufactures something someplace else, um, first of all, it would be they wouldn't be able to get a patent on it in another country because your work has already preceded them. It's like this is prior art; they can't get a patent on it. It doesn't prevent them from, say, manufacturing something if there's no patents in that country. But the laws on patent infringement also include importation. And so, if somebody wants to import into the United States, that's an act of infringement. And so you can protect against that. In that case, the usual route for enforcement is through the International Trade Commission, the ITC, and ITC actions can literally halt the ships at the port and say you may not bring these things in, and so they'll do that. So you can have a very powerful remedy of going to the ITC, and ITC actions are move quickly compared to other forms of patent litigation. By statute, it has a very, very fast timeline. So if you see somebody importing something, then you can take action quickly.
So you keep mentioning that a lot of these are very preventative measures, like filing patents and so forth. You've mentioned a few times the word cost effectively or cheaply or
Yeah,
that kind of concept. Can you give an example as to how much it costs? Because I know you have filing fees, and of course, you should always use an attorney. And you're an amazing attorney doing this a hair under 20 years. What is the approximate? Because attorney's fees are approximate because everybody can charge differently, right? But
right.
what are the filing fees?
Yeah, so I think you're specifically asking about what does it cost to file like a patent application. Uh,
Right.
yeah. Okay. Well, let's start. So for a copyright registration, you can file for a registration, and I believe the number right now is about $75. So that's
That's
like I
it.
said, that's yeah. So that's like I said, it's inexpensive. So and one registration can actually cover a couple different things if they're interrelated. So for example, let's suppose you create a collection of artwork. You can put a couple of different pieces of artwork together in one copyright registration for $75. So that's why I'm saying so
Wow.
copyright protection is like I said, it's inexpensive. A trademark registration costs $350. So that's, like I said, relatively inexpensive. A new patent application, it depends on the size of the applicant. So if you're a large organization, you pay what's the full fees, and then if you're a smaller organization, you pay like roughly half. And if you're a micro entity, which a bunch of individual inventors would qualify for, you get pay 1/4. And so let's just say, so for the a typical price for filing a new application is about $2,000. Um, um, but the bigger expense for preparing and filing a patent application is actually the cost of paying your patent attorney. It's just like that's the biggest cost is really making sure that you get a good patent attorney who does a good job, and that's the biggest value that you have to deal with. So much more than the filing fees.
Well, I think that one of the most important questions I would have is, so I'm sitting right now in Florida and you're in California. And so my question is going to be is working with a patent attorney state by state, or how I thought I would be is federally. So I could work with a patent attorney anywhere in the country, such as yourself being in California.
Absolutely. And yeah, so the question is like, where does your patent need to be relative to where you are? And and
The
so
attorney
yeah,
you're
yeah,
working with.
yeah. So as long as the patent attorney is in the United States, it can be anywhere. So and in fact, I have clients throughout the world. But
Right. So how do
if
you have
they
clients in other countries?
uh, well, if they want U.S. patents, then they need to come to a U.S. attorney. In fact, about just recently, the new rule came out that says they're actually more enforcing the fact that any U.S. patent filings need to be done by a U.S. practitioner. So it was sort of strongly recommended before, but it wasn't an absolute rule, whereas it is an absolute rule now. So yeah, if you want a U.S. patent, and U.S. patents are more valuable than patents in any other country because of the sheer size of the market. Whereas say in Europe, it's like you can get a patent, but then you need to actually pay for individual countries in Europe. Whereas you file in the
Wow.
United States, you get a patent that covers all of the United States. You don't get a patent that's just covering just Florida. You get a patent that covers the entire United States. And so a U.S. patent is very valuable. And so a lot of people throughout the world are uh, actually file first or exclusively in the United States just because that's the biggest market.
Wow. So do you see, because of the explosion in the last few years specifically with influencers, because if you're an influencer, let's say social media influencer, that's a brand name. You're promoting a brand. Do you see a lot of influencers registering with you to protect their brand, that they're it takes money. It takes money to promote the brand, get a lot of followers in to create that level of being an influencer.
Yeah. So from an intellectual property regime, that's again, it would be primarily just the copyrights and trademarks, because um, there's probably not something that would need to file for a patent on, or I mean, there may be trade secrets like business plans or other things, but the main two things are going to be trademarks and copyrights. And I do have I've been doing more trademark filings for people, because yeah, everybody does need to protect the brand, and a trademark is one of the most effective ways of doing that. Of course, people have to um, monitor their mark to make sure that others are not using it. There's no police force out there that is enforcing our rights. You have to monitor that yourself.
Yourself, right? Or have someone do it for you, pay someone to do it for you.
Yeah.
I just think of it this way: when you have 1.9 million podcasters, then you have all these social media influencers, and then you have the YouTubers. We're talking about millions upon millions. They should all be protecting their brand. So then I'm wondering, what is the difference between knowing if they should be looking at a trademark or a copyright? What's the difference between the two?
Yeah. So the a trademark is going to protect the brand name, and so your brand of ask an attorney, the attorney's guide. That is a brand, and so it should be protected by a
Right.
trademark. Yeah. On the other hand, the content of that people are creating, if you create a podcast or you create other content that you're putting on Google, that you would protect by copyright. So it's sort of the name versus the content. So the name would be protected by a trademark, whereas the content by copyright.
So I realized something. I've written several books, and then you have a lot of the self-published authors, and then you have over 57,000 certified coaches. And a lot of those coaches create their own coursework, their own workbooks.
Right.
So obviously, a lot of that is copyright, like a book is a copyright,
Yep.
correct?
Yep.
So then my question is, does that coach have the means or should they be protecting through trade secret? What is it that they're doing to be unique? Because there's so much competition in the realm of business coaching, life coaching, health coaching, all these different types of coaches that exist.
Yeah. In most cases, it would be difficult to protect their methodology um, by a trade secret because it's the usage of that coaching technique is inherently public. You have either one-on-one or group coaching sessions. You describe it, you write about it, and everything. So it's probably not protected as a trade secret just because you can't keep it secret. And that's an important thing to think about. Is I want to think about trade secrets. As I go, how easy is it to keep something a secret? That's when uh, but I mean, and unless there was say, I don't know. Yeah, I would say there's no absolutes. If under specific circumstances, I could probably come up with a trade secret, but in general, probably not for that coaching. So
Because they have to be unique, otherwise, why them versus all their competition? Just like how
right,
there's 1.3 million attorneys in the United States. So is what they're doing and creating unique. So that's what I would be thinking about as an entrepreneur.
yeah,
But
yeah, and
I know we only have a few minutes left. Believe it or not, we only have about 7, 8 minutes left, and I want to ask some more questions here.
okay, go for it.
So
Yes,
so I understand about trade secrets, you need to keep it secret. That's the key word there. I get
right.
that and I understand that. But what are some of the instances where only trade secret protection is possible?
Yeah, and that's the one we actually talked a little bit about that, which is the things that are not inventions, and so it's things that are business methods, client lists, data, and that sort of thing is something you can't get a patent on. So therefore, a trade secret protection is really the right way to go because you can't protect it as a trade secret. Yeah.
And what happens? I know you gave some examples going into technology where trade secrets or patents are used, but can you give an example? Because I mean, you've been an attorney almost 20 years, and I would love to hear if you could just give us one example of that.
An example of
When somebody had an issue because somebody had attempted to reverse engineer their invention, so they had potential patent infringement.
Oh, yes. So let's give some. I think this is useful. So when with a couple examples that I've gone dealt with was say like um, there is some innovation in database design and implementation on a server, and great technology. And then the question is, okay, but this technology is sitting on a server, and it's like, well, who's going to see this server? Who's going to see what's going on? Uh, and the answer is probably nobody. And the same thing is like, and if somebody were else were using the same technology, would you even know? And the answer is probably not. And so in that case, it's like, yeah, you could file a patent on it, But you might be better off just saying, well, let's just keep it as a trade secret because people aren't going to see this. We can keep it as
Oh,
a trade secret. We can keep it as a trade secret forever, and let's just not because the disadvantage in that case of filing a patent on it is a patent then becomes public, and that means you're telling the
ah,
world about it, and so then everybody else could say, "Oh, that's great technology. I'll do the same thing." So in that instance, it's like, well, let's keep it a secret and not tell somebody else about it. On the other hand, let's take an example of say there's a lot of software and you can create a user interface and user interfaces can be patented. It and But of course a user interface by its very nature is completely public and everybody can see it. So, there's no way you could try to keep that as a trade secret. So that's inherently something, if you want to protect it, you would file for a patent. A third example, oh, sorry, I interrupt you. Go ahead.
I was to say, what about there's so many people creating apps. So, for example, a dating app could be unique, or I mean, if they do something special,
Yeah.
or gaming apps. There's so many different types. Is that fall under specifically patents because it's technology?
As long as there is technology, it is certainly something that we could patent, and particularly if it is something, uh, if the technology is visible or could be reverse engineered, then the patent protection is the right way to go. Sometimes, I mean, maybe you have, like I said, like a dating app, but maybe your real interesting technology is some clever algorithm that you've created that runs on the server to determine how you match people together. And you can say, yeah, could be, you could have the best algorithm in the world. It's like, well, okay, people can't figure out what we're doing. In that case, keep it as a trade secret. So
What if one day somebody combines gaming and dating apps
yeah,
somehow?
absolutely, yeah, yeah. And so in a lot of instances, there could be both patent protection, say for a user interface, and trade secret protection for some of the back end algorithms that other people can't see. So you frequently end up doing both, and that
Oh
that
wow,
could be the right way to
blended.
do it. Yeah.
Oh,
Yes.
and then trademark, you got the name.
And of course, you
You're
got a trademark on
trademarking
the
the
name too.
name.
Yes. Yes. Absolutely.
Just like I bought I own at least 50 domains because once you have an idea, you have to get the variations on the idea to prevent competition. Sometimes I think it's a kind of like an addiction I have to having
Yeah.
ideas. But my point is, I imagine an entrepreneur would be the same because once you're creating a unique software, like taking the example of, and I am not doing this, I'm just giving an example. Let's say you have a gaming app that blends dating with gaming. So you have the name, the technology, the patent, the copywriting of the terminology that's being used to advertising it. So then you need to blend all three. Is that correct?
Yeah. 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 You could easily
Or
use
four
use.
trade secrets on how you did it.
Yeah. Absolutely. You could be using you could be using all of those. Absolutely. So yeah, and that's why in any new situation, it's a good thing to develop an intellectual property strategy. What is your overall strategy to protect your business? And they can, the protection of the business can occur in multiple forms. One thing I wanted to bring up, what you just said about the domain names. And domain names are kind of important because even though we don't usually consider that intellectual property, it is closely related to intellectual property and can be very important to get early because frequently you want a domain name that corresponds to your name that you're going to have a trademark on. And so I strongly recommend that people get the domain name first.
First.
And I've actually just recently had a prospective client that they had filed for a trademark and gone through this process. And at the time they got allowed, then they said, okay, now let's try to get the domain name. And the domain name was not available because somebody else had taken it. And in fact, you've got cyber squatters who monitor trademark filings, and if they see a trademark filing for a name that the domain still exists, they're going to buy up the domain name and hold out to have this person pay them money for it. So that's why get the domain name first. And
That's why I own about 50 of them. I know
yeah,
that.
yes. So yes, you're doing it right. Absolutely.
And I don't want to say it's an addiction, but I'm being proactive
Yeah.
for blowing up every single one.
Yes.
That's why I told you, when I said I'd love IP, I wasn't joking.
You really, yeah. Yes, you really do love it.
So I know we have to wrap up. So I've got to ask you, can you come back to talk even more? Because I know there's several nuanced aspects we haven't even hit on. We haven't even talked about how AI is impacted. So David, I'm officially asking, will you come back and do another episode of Ask an Attorney with the Attorney's Guide?
Uh, Thank you, Vivian, for inviting me back. Absolutely, I'll come back because you are right. There's a lot to discuss, and I'm happy to be talk about more about what we've done today, and then also how AI affects all of this as well, because that's changing things as well. So we need to talk about that.
Changing
Thank
things
you.
very quickly. So let's take care of this and come on back soon. And thank you, David. You are an amazing IP attorney, and everyone should be contacting you who has a passion for creating something new. Think about it, all those influencers, all those podcasters, all those book authors, and all those YouTubers. They all should be protecting their brand and calling you, David Sanker, at Sanker IP. And we'll see you back really soon on another episode of Ask an Attorney, the Attorney's Guide. Thank you, David.
Great. Thank you very much, Vivian.